Further hearing in the appeals has been on the application of DA and DS and others against Secretary of State for Work and Pension.
My lady, my lords, just before Mr Shelton gets up, there should be a note on your desks with respect to the childcare entitlements, the point that I think my Lord Reid mentioned. It's been circulated this morning, but not yet agreed by the Secretary of State. I hope it's neutral and is uncontroversial. It largely reflects the table that the Secretary of State's got in his case at MS 8385, I think, where it's set out in shorthand, but you've got the actual statutory references there.
Good. Thank you. Yes, Mr.
My lady, we'll let you know if we have any comments to make on that subsequently.
It's helpful. Thank you.
My lady, my lords, the Secretary of State for Work and Pensions resists both of these appeals. In the appeal in the DA case, which is the claim that lone parents with children under 2 should be exempt from the benefit cap, we say that the majority of the Court of Appeal reached the correct conclusion that there was no unjustified discrimination against the under 2 cohort. In respect of the DS appeal, where they contend that the benefit cap is unjustified discrimination against lone parents or their children, or as fallback positions, lone parents with children under 5 or their children, or lone parents under 2 or their children, and or it's irrational, we say that the High Court correctly dismissed the claim, that their contentions are wrong in law. Now, in my submissions, I'm going to do a number of things. I just want to set that out at the outset. I'm going to present some headline introductory points. I'm then going to take the court to the legislative regime and the passage of the bill and the making of the regulations for you to look at what was actually considered by the decision makers in this case. Then I will deal with the allegations of discrimination, looking at it conceptually, but also looking at justification, looking at the legitimate aims. I will then deal with the role of the UNCRC, and finally I'll deal with irrationality. As you will have appreciated, there have been a very considerable number of arguments deployed by the appellants and the interveners. We have submitted a very full case to the court with our response. I will not be able to cover everything that's been said against me in my oral submissions, but I'll try to do as much as I can. But I do urge on you to read our case carefully, and I know that you will.
And we certainly will not assume that just because you don't mention something when you're on your feet, you're abandoning the point or not thinking it important.
My lady, thank you very much for that indication. So, headline points. First headline point. The benefit cap legislation is an important piece of social and economic policy and was subject to considerable scrutiny by Parliament. It is a matter of what we would say is high policy.
Thank you.
And what we know is that Parliament was very clear that it wanted a benefit cap and that it should be set at particular amounts depending on geographical location. That amount, or those amounts, reflected the earnings, not income including benefit, but the earnings of working families. And we can see that, and I'll take you to that shortly, in the impact assessment prepared in July 2015 at the time of the second reading of the bill. And in that document, it explains that the cap is set at a level which is equivalent to the earnings of around 4 in 10 households in London, that's for the London cap, and around 4 in 10 households outside of London, but also in the context of the broader economic situation. But it was clear on its face when the bill was going before Parliament what the cap level reflected. It was not arbitrarily set. We say, in this context, very considerable deference should be accorded to Parliament's view as to what is an appropriate cap, an appropriate level of benefits, as well as considerable deference to the executive with its implementing regulations. We say that this court should not interfere unless Parliament or the Secretary of State were manifestly without reasonable foundation in introducing the legislation or the implementing regulations. And we say that the manifestly without reasonable foundation test applies to all stages of the proportionality test, including the fair balance. That's deference, we say. Second point, none of the appellants and none of the interveners allege that the amount set by Parliament as the limit of benefits to be paid to those who don't fall within the exemptions breaches substantive convention rights. They do not allege that there has been a breach of Article 3 of the Convention or Article 8 of the Convention, nor do they allege that there has been a breach of any of the substantive obligations under the United Nations Convention for the Rights of the Child. You heard yesterday about Articles 26 and Articles 27. They do not allege that those articles have been breached. That non-contention, the fact they haven't even alleged it, leads to an assumption, we say, that the amount set by Parliament is lawful in terms of the European Convention and in terms of the substantive rights under the UNCRC. And we say it's not surprising that they haven't brought such a challenge, because they would have failed, we say. You may recall that a challenge on that basis was brought in the JSSG litigation, but was rejected both by the Divisional Court and by the Court of Appeal, and was not appealed to this court. And I would like to take you at this stage to what Lord Dyson, the Master of the Rolls, said about this in his judgment. Now, that decision you find in Authorities Volume 9, tab 76, or MS 3100. Tab 76, MS 3100, the Court of Appeal, Lord Dyson, Master of the Rolls, and Lord Justices Longmore and Lloyd-Jones, as he then was. And I'd like you to have a read of paragraphs 94 to 105. Which you pick up at 3126, my lady. But that's where we see the arguments that were made by Mr. Wise, who was representing the claimants in that case, in respect of a substantive breach of Article 8. If you look at that, or skim that briefly, because I want to take you to the conclusion at 105, and maybe you'll come back to look at the rest of it at your leisure. But the argument that was run there were substantive arguments around...
I don't think you mean leisure, Mr. Chairman.
I mean, when you have more time.
That's it, yes. So
We
get to the bottom line in paragraph 105.
The argument that was made by Mr. Wise that the cap as set under the original limit was in breach of Article 8, that it amounted to putting the benefit recipients into destitution. At paragraph 105, Lord Dyson, speaking for the court, said this: "We have no doubt that some families will suffer hardship as a result of the application of the cap. the cap will bear particularly harshly on larger families and single parents. However, having regard to the sums which are available to the claimants on a weekly basis, we are in total agreement with the Divisional Court that the circumstances of these three families, including MG's family, who actually withdrew the case when it went on appeal, but was in a much more serious, had a more serious financial impact, do not approach the level of destitution. Accordingly, we conclude that the claimants fell well short of demonstrating a breach of Article 8. And I remind you that in our case, it's not even argued that there is a breach of Article 3 or Article 8 of the Convention. It's not argued that that the system presents a systemic risk of a breach of Article 3 or Article 8. And in this connection, I would also like to remind you of what Lord Reid said in the SG case at paragraph 72. And you pick that up in Authorities Bundle 2, behind tab 16. And that's MS 335. That's where we find SG. And I just want to take you to Lord Reid's judgment at paragraph 72.
Page.
So that's at 357, my lady.
Thank you.
357. In relation to the reduction in income, it has to be borne in mind that the cap for a household with children, this is the original cap, has been set by Parliament at the median earnings of working households, equivalent to a salary of £35,000 per annum. By definition, half of all working households earn less than that amount. The exclusion of child benefit and child tax credit from the welfare benefits counting towards the cap would enable non-working households with children to receive an income from public funds in excess of that amount. Whether that level of benefits ought to be paid by the state is inherently a political question on which opinions within a democratic society may reasonably differ widely. It is not the function of the courts to determine how much public expenditure should be devoted to welfare benefits. That's a very important principle. Now, this is not a substantive challenge, as I've explained, but of course it is a discrimination case. And we say that the fact that the welfare benefit is lawful when looked at in the context of Article 3 substantive, Article 8 substantive, as well as the UNCRC substantive articles, is very relevant to the justification analysis, if you get to the justification analysis. Weighing up a lawful amount of benefit, along with all the policy reasons why the cap has been set, against the detriment, is what you will have to do. But you should bear in mind when doing that the detriment does not fall below a lawful level. The lawfulness of the amount fixed by Parliament has to be borne in mind when deciding how much weight to attribute to the detriment. I also remind you that the court should not be focused on individual cases. The focus is on the system. Again, Lord Reid referred to this in SG at paragraph 15, where his lordship quoted from the Carson case, and I'll ask you to look at that again when you have more time. But that's at paragraph 15, MS 344. We recognise that the appellant's cases are hard cases. We do not accept, however, that they are typical of all the cases, even the majority of the cases of individuals who are caught by the revised cap. That was my second point. My third point is that the aspects of the legislative regime that come in for particular criticism, the application of the benefit cap to lone parents, the application to lone parents with children, including children under 2, were matters that were debated, and exemptions about them were specifically rejected by Parliament when passing the primary legislation, and with no expectation that they would be introduced as part of the regulations to be filled in by the Secretary of State. We also say that exempting the cohorts of lone parents, whichever cohorts one is looking at, but even more so as the cohorts get bigger and bigger and bigger, would be to compromise unacceptably the legislative intention. And my fourth headline point, and we will deal in more detail with discrimination later, is that if you are looking at the financial impact of the cap, that impact is not determined by the age of the child. The financial impact will depend in particular on the number of children and the geographical location. It's also correct that the impact of the cap financially is actually greater for couples with children than it is for lone parents with children, because they have the same cap, but they have one more mouth to feed, body to clothe, etc. The financial impact on couples is actually greater than that on lone parents. So, my lady, my lords, those are my headline points. I now would like to take you to what I think are relevant parts of the legislative scheme and also the debates and matters that were considered by the decision makers. Now, yesterday, or in fact the day before, Mr. Drabble took you through the legislative scheme in some detail, and I won't repeat that. How the cap operates, how the legislation operates, we set out at paragraphs 14 to 31 in our case. In our case, you find in the core volume at 8370. This part is at 8370. I'm not going to take you through that, but it's there and I know you'll look at it later. But what we do know are a number of things about the statute, the amended statute. Parliament has specifically authorised the respondent to apply a benefit cap to couples and single claimants. Parliament has specifically authorised the Secretary of State to set that cap by reference to the annual limit enshrined in section 96(5)(a), and those amounts are set out on the face of the statute. Parliament has specifically authorised the Secretary of State to set the relevant amount by reference to 2 specific annual limits for those within London and 2 for those outside of London. And Parliament has specified that the respondent must apply any cap to each of the benefits listed at 9610, including child benefit and child tax credit. And those were matters that were subject of specific debate. In terms of the implementing regulations, the amount set, we looked at that with Mr. Drabble at the beginning of his submissions. The Secretary of State made the decision to set for lone parents, to set the cap at the higher of the levels, the highest possible level available to the Secretary of State under the statute, not to set it at the lower level, but at the highest available level. We also see in our case a description of the exemptions. Not all of those exemptions, and we see that at paragraph 30, not all of those exemptions relate to the ability to work or difficulties in working. You see, for instance, references to those in receipt of war pensions. You see reference to guardian's allowance, where policy reasons were used to justify those exemptions. We also refer at paragraph 31 to the grace period. There is a 39-week grace period before the cap would be applied, where you had been in, or your partner had been in full-time work.
Mr. Sheldon, could you just remind me where we get the 16-hour requirement for eligibility for working tax credit?
Try and find
Or
that.
could that be supplied at some stage?
That can be supplied.
Thank you.
I think the language on the face of the regulations is those entitled to working tax credit.
That's
Everyone
why
has
I
to
asked
read-
the
Everyone has
question.
to read it back.
I think so.
Yes.
Thank you.
But as I say, there's a grace period. And then how does the cap work? It's not that all or any of the individual benefits get reduced or that child benefit gets reduced. What happens is that housing benefit is reduced. It's also important to note that the benefits that form part of the calculation that are in that list are payable to and are the entitlement of the adults and not the children. The DS appellant, certainly in their written case, contended that the cap fell within the ambit of Article 1, Protocol 1 of the Convention in respect of the children, not in respect of the, as well as in respect of the adults. We accept it does in respect of the adults. They didn't make much of that or any of that really in their oral submissions, but we say it is wrong for them to have made that contention in the first place. It's not a technical point for us to say, as we do in our case between paragraphs 34 to 42, where we set this all out, that this can't fall within the ambit for the children of A1P1. They have no entitlement to the benefits. They have no expectation of an entitlement to a benefit. No legal entitlement or expectation to an entitlement is being taken away or reduced. Now I'd like to take you through what was considered by Parliament and by the Secretary of State when they made this legislation. Now, we can't ignore...
Could I just ask a question? It's only just occurred to me. What's the position if the recipient, anybody, recipient of benefits, doesn't actually claim housing benefit? It's a not inconceivable question.
Then under the legacy benefit case, so before we look at universal credit, they would not be they would not be capped. They would not be capped. And in fact, I think we have an example. I think it may be DS as the example here, where her housing benefit is actually very low, and whereas other benefits are much higher. But all that can be done under the legacy benefit regulations is to reduce the housing benefit, leaving her with the other benefits.
But that doesn't operate under universal...
Under universal credit, everything is...
Everything's
built
in
up
one
together.
place, yes.
Everything's in one place. As to what was considered by Parliament, of course, we're concerned in these appeals with the amended legislation, but we can't ignore the original legislation, because that set the framework for the cap and the understanding of Parliament for what the cap was supposed to be achieving and doing. And I can't better the description of what was said than Lord Reed's judgment in SG between paragraphs 17 to 58. You find that it's in tab 16 of the authorities bundle, and my lady, you find that at MS page 344. If I can just pick up a few points that were made there by Lord Reid, but it's important for the court to be familiar with the background, and it's set out there. I'd like to take you to paragraph 28 at page 347, where Lord Reid said this: "The discussion in committee and in the earlier second reading debate concerned a number of issues, including the impact of the cap on single parents, its impact on children, its impact on those living in temporary accommodation, and the appropriateness of fixing the cap according to the net median earnings of working households, when working households receiving net median earnings might also receive certain benefits." And then at paragraph 32, "In relation to the use of net median household earnings as the benchmark, it was argued that the cap would leave the households effective worse off than working households with equivalent earnings, since some benefits were paid to households receiving average earnings. An amendment was tabled in committee to require the cap to reflect net average earnings plus in-work benefits which an average earner might expect to receive." That was not accepted by Parliament. The importance of that is that it was always understood by Parliament that there was no equivalence between those subject to the cap and those with in-work benefits. The principle of fairness, which underpinned the legislation, and we rely on that as one of our legitimate aims in this appeal, was not predicated on equivalence. It never had been. There was no suggestion previously, and there's no suggestion under the amended legislation that we're concerned with. It was well understood by those making the decisions that those in work could also receive benefits and considerable amounts of benefit. That was not what the cap was seeking to do. So you've seen the evidence that's been put in by CPAG on this, Ms. Garnham, and you've heard the submissions from Mr. Drabble about equivalence. We say that's not relevant to the analysis in terms of does it undermine the fairness argument. Parliament knew that. Parliament was aware of that, and they were aware of that again when we get to the 2016 legislation. So moving on from Lord Reid's description of the earlier legislation, and I want to turn to the legislation at issue in this appeal. And why was the lower cap introduced? It was said, well, there was no green paper, there's no white paper, there's nothing upon which one can fix what Parliament had in mind, what they understood. But we do have the impact assessments, which are prepared for the purposes of explaining to those who are dealing with legislation what the government is intending to achieve by their proposed legislation. And we can pick up the impact assessment at MS 5462, and it's in Appendix 3. I'm just going to make sure I get the right appendix. I think it's the DA Appendix. DA Appendix 3 at 951. Yes.
Is that the MS number?
That is, no, the MS number is 5462.
Thank you.
You were taken to parts of this document by my learned friends, but I think it pays a little bit more attention, or requires a little bit more attention, because it's signed off, you can see at the bottom of the page, by the responsible minister. It's dated at the top of the page, July 2015. So it coincides with the second reading of the bill.
So this is the original cap?
Nope, this is the revised cap.
The
revised cap. And you have in the bundle the impact assessments from the earlier caps, but this is the revised cap.
Of course it is, thank you.
You may recall there was a general election, I think in May 2015. The new government was formed. Shortly after they came into government, they introduced the bill, and this coincides with that. The bill was enacted in 2016. And what this sets out in the first couple of paragraphs is what was the problem under consideration, and then what were the policy objectives.
Can you just remind me, is impact assessments of this kind laid before Parliament, or placed in House of Commons Library, or something of that kind?
I'll have to find the answer for that over lunch.
I'm just wondering if they in any formal or
I think it's actually,
practical way, they form part of the consideration of the legislation.
I think it is certainly referred to in explanatory notes, but I will find the answer to that. But here, this is the impact assessment. And what it sets out is the problem under consideration, that the current cap has been shown to be successful with more households looking for and finding work. The long-term positive intergenerational effects from people moving into work are well known, and therefore to encourage more households to move into work, a new lower tiered cap has been designed to strengthen the work incentives for those on benefits. It also helps in tackling the deficit and consequent reductions in public expenditure that the government is making to return to sustainable public finances. Evaluation evidence shows that the existing benefit cap is improving work incentives, promoting fairness between those on out-of-work benefits and taxpayers, and delivering savings. Reducing the cap builds on this, delivering further positive change. What are the policy objectives and intended effects? The objective of the policy change is to build on the successes of the existing benefit cap, as shown by evaluation evidence, and I will take you to that evaluation evidence. It is said against me that government and Parliament didn't ever even look at these matters to know how the cap had worked. So therefore, how could they then properly consider a new cap going forward? Well, that's just simply wrong. There was evaluation evidence. And what they say here is, we will do this by restricting the total amount of benefits that a household can receive to 20,000 in Great Britain and 23,000 in Greater London, and 67% of these levels for single people without children. By doing this, the policy will further improve work incentives for those on benefits, promote even greater fairness between those on out-of-work benefits and taxpayers in employment, who largely support the current benefit cap. In fact, the benefit cap, a reduction in the benefit cap, was part of the Conservative manifesto before the general election.
Mr. Sheldon, before we go any further, can we just understand the nexus between the impact assessment that we looked at yesterday and the day before, which starts at 966,
Yes.
and which is dated August 2016, and this one that you're reading to us, which is July 2015. Yes. There seems to be similarities, but no doubt there are differences.
Absolutely.
Why are there two? And explain it, please.
My Lord, there's an impact assessment when the bill is being debated, so that it informs the debates, both publicly and I suggest for members of the House. And then there's an impact assessment once the legislation has been enacted. So the second one that you see is written a year and a bit later, because that's when the legislation had been enacted.
And were there significant changes between the bill and the Act, such as to require a substantial difference in impact assessment?
There were very few changes in the legislation. What you will see in terms of changes here are the number of households that were expected to be caught and so forth has changed. So some of the evaluative evidence has changed.
What is the purpose of the second impact assessment, and who does it go to?
Well, again, the purpose is it's the government having looked at the legislation and saying this is what the legislation is intended to achieve now that it's been enacted. It's publicly available, it's available to parliamentarians, and it is pre the regulation stage. So the importance is that those who are then making the regulations and those who are debating the regulations, and we'll come on to that, because the regulations here were scrutinised in Parliament.
And I understand all that. I'm just follow up to the question. I'd like to have clarity as to what exactly the legal status or constitutional status is of these impact assessments. But by all means,
I will seek to explore that.
Yes.
But I think what we can say...
because we need to know, A, whether they're relevant in any way to interpretation, B, what we're supposed to do with them if it's suggested that the evaluation was based on false material. I mean, I can't believe that it's our job to sort of scrutinise the accuracy of the information in those impact assessments.
What I'm seeking to show with these documents is what was understood by those who were making the decisions as to what the cap was about, what it was seeking to achieve, and what its impact would be.
And whether it was actually achieving
what it was actually achieving. Yes, but
if there is an interference with the with the Article 8 right, I mean, I know that you said there's no substantive allegation that there is an interference with Article 8 right, but if taken together with Article 14 there is considered to be an interference, the justification endures, doesn't it? The need for justification continues.
Yes, and the need for justification would continue even up until today.
Yeah.
And I accept that, which is why I'm going to take you also to the equality impact assessment.
So these impact assessments are relevant as to the enduring justification.
They are relevant to the enduring justification, absolutely. And but what I'm seeking to use them for at the present time is to show you what was before Parliament or was available to Parliament at the time they made the decisions. What were the policies, purposes and so forth.
I suppose if you think about it, we're being asked to defer to the assessment made by another institution, whether it's government or Parliament. And so it's relevant for us to know what assessment they actually made and what materials what factors they took into account.
Yes.
And certainly that would be looked at if this were to go to Strasbourg.
Yes. And well, that's precisely what we're seeking to achieve.
Yes,
through taking
I mean, I hear what's said. My part, I think that's rather more difficult. But I mean, anyway, well, let's see where we get to.
my Lord,
Well, we're a bit on the misbehaving point, aren't we?
Well,
that if the decision maker has actually taken into account matters which are relevant to whether there's a breach of the convention, that is helpful in understanding how much weight we should give to the decisions which that decision maker had made. And that's, I think, what you're trying to show.
That is what I'm seeking to show.
Yes.
It's been suggested that, in a sense, there was no proper consideration being given to the impact of the legislation, and it's said that the legitimate aims aren't rationally connected to the to these particular cohorts. I'm seeking to show from the material that was available at the time for the decision makers that isn't right, and I'm suggesting that this goes into the manifestly without reasonable foundation pot when you come to look at Article 14, if we get to Article 14.
I suppose if there's any anxiety arising from Article 9 of the Bill of Rights, on any view, this would be relevant to our understanding the thinking of government.
Yes, yes. I mean, even if it's not relevant to Parliament, I'm essentially wanting to show you this for one reason for Parliament, is because it was suggested that Parliament didn't understand what the amounts were being set at, and that it was an arbitrary figure. That was the submission made by Mr. Drabble. And this will show you, as I've headlined before, that they must have known. But when it comes to government who are making the regulations or not making regulations, which is the way the case is put, why is that? And what do they take into account? But if I can go back, it's just chronologically, I'm taking you to the July assessment. I'm very happy for you also to read the August one later, but I don't think there will be a lot of repetition. But 5462, MS 5462, 951 in this bundle. The second box relates to the policy objectives. The third box deals with the three options that were considered by government. Should they apply the cap to all working age benefit recipients? Should they leave the cap where it was? Should they lower the cap to build on the current success of the cap in improving incentives to work, delivering fairness and benefit savings? And they say removing exemptions reduces fairness and work exemptions despite increasing savings, and so was rejected. The current cap meets policy intentions. However, there is opportunity to further build on its success with a lower cap. We believe the lower levels further enhance work incentives while striking a balance between claimants' and taxpayers' interests for fairness and spending and ensuring a safety net for the most vulnerable. It is therefore the chosen option. So that's certainly government's view when they're introducing the legislation. Then over the page you have an economic assessment, and there they talk about the number of households they're expecting to be caught, which is essentially 90,000 more than under the current policy. In fact, the number was less than that if we look at the following years. Impact assessment. And then it talks about all households taking action to move into work will be unaffected. Those not responding will have their benefits reduced by an average of around £63 per week, median £50 in 2017-18. So an awareness of the average and the median that will be reduced from the cap. What is it that a family or a benefit recipient may lose in terms of their benefits? And then I want to turn to page 955, which is MS 5466. And it's essentially, why is the benefit cap being lowered and tiered? Tiered meaning you're having one for London and one for outside of London. And these bullet points are as follows. Well, you can in a sense read them for yourself, but the new lower tiered cap strengthens work incentives, achieves fairness for taxpayers, ensures there's a reasonable safety net for the most vulnerable. An evaluation of the current cap showed households were 41% more likely to enter work than comparable households not affected by the benefit cap, and the greater the amount by which benefit receipt was reduced by the cap, the greater the proportion moving into employment. There's a footnote there, and there's the reference to an evaluation, which I'll come on and show you. That's where the 41% figure comes from. 41% more likely. That is the percentage change, the proportionate change. A lower cap recognises that many hard-working families earn less than median earnings. A lower cap provides a strong work incentive. And again, note the reference to earnings. So whereas the previous cap was set at the basis of average earnings, there's a recognition, well, actually 50% of the population earn less than median earnings. Therefore, that's what the lower cap recognises. The tiered cap recognises that under the current cap, a disproportionate percentage of capped households are in London. Almost half of all households currently capped are living in London. In contrast, only 3% live in the North East. The tiered cap would see a more equitable distribution of cap cases, with around 24% in London. So the current cap, or the original cap, did not have the same geographical reach. It wasn't reaching throughout the country. And if one is wanting to achieve a nationwide policy which impacts on work incentives, promotes fairness, makes savings, it is necessary to lower the cap. Then there's an explanation of why you have a higher cap in London and so forth. And then the next bullet point, the level of the tiered caps is fair and reflects the broader economic situation. For instance, alongside the difference in housing costs, around 4 out of 10 households earn less than £23,000 in London, whilst around 4 out of 10 households in Great Britain, excluding London, earn less than £20,000. And that is footnoted. So it was made very clear, I say to Parliament, publicly, to those reading this document, what the cap was being set at, why it was being set there. And as I said at the outset, that's not arbitrary. There is still a connection that one can make between household earnings, those in work, what they will earn, and what those are receiving on benefits, and that is relevant in particular to the fairness objective. Then there's more detail in this document relating to options for change, why they didn't do one thing, they did other things. Then there's reference 956 to behavioural change. And then if we look at 5468, 957 in this bundle, MS 5468, there's a specific reference to lone parents, comparing them to couples. Lone parents must work 16 hours per week to be exempt. And then there's this expression, children can have their life chances and opportunities damaged as a result of living in households where no one has worked for years and where no one considers work is an option. For example, children in households where neither parent is in work are much more likely to have challenging behaviour at 5 than children in households where both parents are in paid employment. Growing up in a workless household is associated with poorer academic attainment and a higher risk of being not in education, employment and training in late adolescence. Then we have at 958 a reference to savings. 959, there's the reference to the average amount of benefit reduction. Then at 960, so 5471 on the MS, there's a reference to this. This document records the analysis undertaken by the department to enable ministers to fulfil their public sector equality duty obligations. In undertaking the analysis, the department has also taken into account, first bullet point, so this is at page 960, the United Nations Convention on the Rights of the Child, and in particular, Article 2, duty not to discriminate, Article 3, the duty to treat the best interest of the child as a primary consideration, and so forth, including Article 26, Social Security, and Article 27, Standard of Living. They also take into account the Convention on the Elimination of All Forms of Discrimination Against Women. So to suggest that the government, and then we would also say Parliament, did not have in mind international law obligations, we say is wrong. It's on the face of this document. And then there's a reference to gender. So this is, if you're looking at a public sector equality duty, you'd be familiar with these kinds of descriptions. Modelling suggests that around 64% of claimants who are likely to have the benefit reduced will be single females, but only around 12% will be single men. Most of the single women affected are likely to be lone parents. This is because we expect the majority of households affected by the policy to have children. Around 59% of the caseload are estimated to be female lone parents. So a recognition that the cohort who is most likely to be affected by this cap are female lone parents. Then over the page at 5472 at the bottom, a reference to life chances legislation. And then at 5473, page 962, what are we doing in mitigation? Because obviously it's understood that the cap will have an impact. We've seen the financial impact, but what is the government doing or proposing to do to mitigate against those effects? DWP has a number of measures in place to ease the transition for families affected by the policy change, and it sets out a number of those there. And then there's in particular a heading childcare costs. And there's two matters there that are dealt with. Support for childcare costs for those in work is currently provided through working tax credit, and that therefore will apply to all children of all ages. If you work enough to fall into working tax credit, the parent works enough to fall into working tax credit, then childcare costs support will be provided. Then there's explanation about under universal credit. And what is explained, this will help mitigate the impacts of the cap for parents whilst maintaining the work incentive effects of providing support for the costs of childcare for those in employment. And then there's a specific reference to the free childcare for the 3 and 4-year-olds.
How does support for childcare through working tax credit, then it's going on to universal credit?
Yes.
But still talking about people in work. And then it says this will help mitigate the impacts of the cap. How does childcare for people in work mitigate the impacts of the cap?
Well, under universal credit, it's any hours that you work, you receive childcare costs. One don't have to work 16 hours. Universal credit is tapered in a different way than the legacy benefit system. And then we have the reference.
You want to say anything or not about the point that's made, I think, against you in relation to the childcare support for those in work is that it's chicken and egg, catch-22. You've got to get a job first.
My Lord, what you weren't taken to, and I'll come on to that.
If you're going to come to it, do it then.
There is available a benefit called under what's called the Flexible Support Fund, which was referred to during the debates in Parliament, where people can get support for childcare whilst they are looking for work.
Right.
There's a reference in our case at paragraph 48.3 at MS 8383.
Okay.
So in our case, in the core volume, which you see behind tab 10, we talk about flexible support fund. This is available to those who work less than 16 hours per week.
Sorry, which page is this?
Oh, my Lord, it's MS
25.
8383, but it's in your core volume.
Yes, I got that. Thank you.
This is available to those who work less than 16 hours per week and can be accessed where free childcare is insufficient or the parent is not eligible, there's no minimum age, and so forth. So
it's discretionary.
It is discretionary, but it's designed, or that the fund is available for those who want to be able to plan moving into work. So, my Lord, this will, we say, eliminate the chicken and egg problem that is that was referred to yesterday.
Mr. Sheldon, in respect of the second paragraph under the heading childcare costs,
yes.
You know what Mr. Wise says. You know he said, well, the first sentence says 3 and 4-year-olds, free childcare, fine. Some disadvantaged 2-year-olds, fine. And then he says there's an omission. I mean, the writer simply hasn't addressed the under-twos.
Well, the under-twos do not receive free childcare, that is correct, but the under-twos do receive, if they are in work, childcare costs.
Well, we've been through all that.
Yes. Well, that is a distinction, and we accept that. Of course, there's a distinction. The free childcare is a policy of the Department for Education.
Yes. Otherwise, it might be 16 rather than 15 hours, mightn't it? Which would look a bit more joined up.
But it's designed by the Department for Education on the basis, and we set this out in our case, that certainly it's a way of trying to equalise the disadvantage between families who couldn't afford childcare and those who can afford childcare. It is seen that childcare from the age of 2, and certainly from 3 and 4, is of educational benefit and will allow disadvantaged children to, in a sense, catch up with their more advantaged peers. So it's an educational policy, but it has a work incentive effect. But this paragraph is designed to apply to all children, because that's the reference to childcare costs. They get if you're in work, there is childcare costs subsidised up to 85%.
I'm still confused by the first paragraph under childcare costs. It begins by telling us about support for childcare costs for those in work through working tax credit, and then it tells us that under universal credit, similar support will be available where both to all lone parents
and couples where both members are in work. It means, it's obviously not worded very well, but it means it's in work, but it's regardless of the number of hours they work.
Okay, so all lone parents in work.
Irrespective of how many.
It then says payments to support childcare costs through universal credit will not be affected by the cap. Well, that's
you can still be. What it is, it's as if it's a benefit that you receive over and above the cap. It's not the way it operates, but that's the effect of it. So if you're working less than 16 hours, so you don't come off the cap, you can still receive childcare costs, and that's not taken into account as any of your benefits. It's not reduced from your benefits.
So does the 16-hour requirement apply to people receiving universal credit?
The 16-hour requirement is to work the equivalent of 16 hours at the national living wage.
Yes.
There's not actually a requirement of hours, but it's the salary equivalent has to be for 16 hours of national living wage.
Yes, I thought the time, the 16-hour requirement was the effect of providing that the cap wouldn't apply to people in receipt of working tax credit.
That's that's under legacy, under the, if we weren't looking at the universal credit scheme,
Yeah.
if we're looking at the original benefit scheme, it's about working tax credit. Under where universal credit applies, which at the moment applies to a very, very small number of households. I think it's a few thousand households that are relevant to the cap. They have to work 16 hours, essentially 16 hours, the equivalent of 16 hours at national living wage to come off the cap.
Yes, I see.
But what this is saying is even if you work less than 16 hours, even if you work 1 hour, 2 hours, 3 hours, you will have your childcare costs paid, and you don't lose out on that. We deal with that, my lord, at paragraph 27 in our case, if you need to look at that.
Thank you very much.
But the point I'm seeking to make here, yes, I accept there is a distinction between the under twos and the over twos. We'll come on to deal with whether that's a significant difference for the purposes of the Thlimenos analysis. We accept there is a difference. The Court of Appeal majority did not accept that was a significant difference to, in a sense, pass that threshold to even look into unjustified discrimination under Thlimenos. But what you can see is that the government was looking at these issues and is looking to see how can they mitigate against the effects of the cap. Well, actually, they are going to help people into work because they recognise that childcare can be a barrier to work. How do they therefore overcome that? They either subsidise the childcare cost through working tax credit or universal credit, or they provide free childcare, or free childcare is available. And what they're saying is, given that availability, it should be less difficult for lone parents in particular to go into work. And then over the page we have reference to the discretionary housing payments, where they say DHPs make an important contribution to managing the transition for various customers whilst they make the necessary changes to adapt to the application of benefit cap. So that is the original impact assessment. So what is known, we say, by Parliament are the purposes, the rationale behind the set of the cap, and consideration of there is impact on lone parents in particular, how are they going to be assisted. We're mitigating against that impact through the childcare approach. The later impact assessment has some different figures. The number of households is reduced, and the amounts that are cut from the benefits are also seen to be, the median is £49 and the average is £60. But essentially you have very similar material in there. My lady and my lords. Now, we said that there was reference in that document to the evaluation and the reference to 41%. And I want to take you to the evaluation evidence, which you will find in DA Appendix 4, at 5672, my lady, MS 5672, and it's 1161 for those using the hard copy. My Lord, I'm being reminded that in case, Lord Wilson, you may have been concerned that the impact assessment was misleading in that it suggested that there was free childcare available for the under-twos, that we say that's not the way in which one can read the impact assessment.
I don't think I meant to imply that I thought it was misleading. The argument is that there's a casus omissus.
And I'll come on to deal with that in terms
Thank you very
of
much.
significant difference. Yes, but it was well aware to those who were who were drafting. So 5672. Just want to take you to the really just to read the executive summary. This is a Department for Work and Pensions evaluation carried out in December 2014, analysis of outcomes of capped claimants, and what is said at 1163, 5674, talks about what the benefit cap is, talks about the historical caseloads, talks about what's been analysed. And then over the page, 1164, it tells you what the amounts that have been lost through capping. So the mean average loss for the November cohort 2013 was around £70, a median of £46. It also refers to the awards of discretionary housing payments. It talks about support and awareness of the cap, and then impact on employment. And what it says is as follows: movement into work, defined as a household having an open working tax credit claim, has been the main focus of this report. Post-implementation analysis shows that capped households were more likely to move into employment than similar uncapped households. 19% of capped households were in work after a year, compared to 11% for a similar uncapped group, a difference of over 7 percentage points. Even after controlling for a range of observable characteristics, for example, number of children, capped households were 4.7 percentage points, that is 41%, more likely to flow into employment after a year compared to similar uncapped households. What they did was they compared those who were capped and those whose benefits were just beneath the cap. So in the pre-cap world, one would have expected them to have very similar employment careers. But when the cap applied, they saw that there was actually a 41% difference between those who weren't capped and those who were capped. That meant that it was 4.7 percentage points, but the impact, in terms of the percentage impact, is a 41% impact.
I'm sorry, Mr. Sheldon, it's my fault. I'm hopeless with figures, but the 41% is obviously figured quite heavily in the criticism. I haven't got it yet. How do you get to it?
So if you compare, let me read, if I read the whole thing for you, and then we can come back to that.
I mean, it might help. I mean, basically, the difference between 11% and 19% is a difference of 40 odd, isn't it?
Yeah.
And it's been...
It's basically that.
Yeah.
It's actually more.
Okay.
So the figure of 41%, and you see other figures later on in this document,
Okay.
is the percentage. How much more likely are you to move into work if you're capped than previously? And so those who were in work previously, 11% would ordinarily move into work.
Got it.
19% were moving into work afterwards.
That would give you a higher figure than 41, obviously, but you're...
Yes. But they've got variables that they've
It's
adjusted.
4.7%. If you add 4.7, I assume it was 41% and 11.
Yes,
Like
yes. If you divided, I think, 4.7 by 11, I think you get to 41%.
You do, yeah. Got it. Thank you.
Then they explain historical estimates show that the rate at which those in scope for the benefit cap moved into work was very similar to the rate at which those just under the cap did so. So historically, people would go into work at the same rates. This suggests that factors other than the benefit cap were affecting the rate at which these groups flow into employment in a similar way pre-implementation. In turn, this suggests that the differences that emerge post-implementation provide a reasonable sense of the likely effect of the benefit cap. And that was accepted by Mr. Harvey, whose witness statements you have been referred to. You were taken to a one sentence, I think, in Mr. Edson's witness statement, which says, well, I don't agree that there was causation. He's actually referring to some other document where he says, no, it's not that document which shows you that there was causation. He then goes on to talk about this document where there is causation established, and Mr. Harvey accepts that.
You have the reference to Mr. Harvey's acceptance of that.
I will try and find that
When
for you.
convenient, no, thank you. I'm sure it's somewhere in my notes.
Then they go on to say the greater the amount by which the benefit cap was reduced by the cap, the greater the proportion moving into employment. Over 30% of those in the May 2013 cohort who were capped by more than £200 moved into work after a year. Further subgroups have been examined, including by region, lone parents and carers. Historical estimates showed the rate at which those households flowed into work was very similar to the rates at which those just under the cap did. So previously it was the same. And then talks about what happened in London. Nearly a quarter of capped households in the May 2013 cohort in London entered work after a year. This compares with around 13% just under the cap, a difference of 12 percentage points. And that's a 9.5 percentage points, but a 70% increase. And then it says for lone parents in scope for the cap, the proportion moving into employment was over 16% compared to less than 10% for those just under the cap, a difference of around 7 percentage points after a year. When controlling for a range of observable factors, lone parents were 4.9 percentage points. So the actual percentage of people moving into work, of lone parents moving into work is 4.9% difference, the real numbers. But in terms of the proportion, it was 51% more. So 51% more likely to move into work. When looking at lone parents in London, those in scope were 8.4 percentage points, 70% more likely. And then there's reference to carers allowance. And then in terms of households moving house, they conclude that the benefit cap has not led to significant increases in the proportion of capped households moving, which then features later in other analyses. There was no observable or significantly observable statistics in terms of that. But what we see is that there was an evaluation of the previous cap. They did look to see how has the cap operated, what effect has it had. Then I just want to take you to there was some qualitative analysis also carried out, which you see also in this bundle at 5630. It's the first document in the bundle, but it's page 1119, my lord, but 5630 for the memory stick, which is based on in-depth interviews with people affected by the cap. So again, there was an evaluation, a consideration of what did the cap actually mean to people in real terms, asking questions and asking them to explain. And there's a summary at 5632, MS 5632. And just to pick it up, 6 paragraphs in, there's the word around, if you find that, around half those interviewed reported no change in their attitude to job seeking, usually because they'd already been looking hard for a job. And half said they had looked harder or altered the types of jobs they would consider in response to the cap. This usually entailed being willing to accept low-skilled, low-paid jobs rather than pursuing further qualifications, which they hope would help them get a better job in the future. The main driver for looking harder was a desire to avoid the cap and have full housing benefit reinstated. Some households had moved to lower-cost housing. Nearly all households were already on very tight budgets before the impact of the cap. Most had debts including unpaid bills and overdue loans, some of which predated the cap, but others were taken out since. Coping strategies included cutting spending and getting support with budgeting from voluntary sector agencies. Some described having insufficient money for things such as weekly supermarket shops and utility bills. A quarter of those interviewed were under threat of eviction and said this was because of arrears related to the cap. Many of those affected by the cap said they could understand the rationale behind it and agreed with the principle of it, even though those still affected often felt that their personal circumstances made it very hard for them to cope with its effects at the current time. So not as if the government wasn't trying to see what the impact was, and they could see from the quantitative survey the kind of reactions that people had. On the one hand, one can see the evidence of work incentivization, people actually looking harder for work, wanting to get into work, and others saying how difficult it's been on their budgets and in terms of their expenditure. So it's not as if the government wasn't looking to see what was actually happening. They were aware of the impact, they were aware of the consequences. Now, moving on from the impact assessment and the evaluations. In terms of Parliament, what took place in Parliament, we know that there was, as you saw yesterday, a memorandum provided to the Joint Committee on Human Rights, provided by the Secretary of State, and at paragraph 77, I think you have that as a separate loose item. Just to take you to the first few lines.
What's the date of this?
My lady, we think it was...
I've got 8 September 2015. Could that be right?
I think, my lord, that should be right. 8th of September 2015. So if we think the bill has only been introduced in July, this is a few months later. In relation to clauses 7 and 8, which is the reduction of the benefit cap, the government notes the Supreme Court's decision in SG. But in relation to the reduction of the cap, the government has fully considered its obligations under the UNCRC, and in particular Article 3, the duty to treat the best interests of the child as a primary consideration, and Article 27, standard of living. And then goes on to set out various other matters as to why it's doing what it's doing. But it cannot be said that government did not properly, we say, take into account Article 3 or apply Article 3. Now, in our case, we set out in some detail the various amendments that were made and discussed, and you can see that at paragraph 68 to 70. Which is MS 8394, and I'm not going to take you to that in any detail. That you really don't have time. But you did get taken yesterday to what was called the Thornbury Amendment, which is referred to at 5518, MS 5518. It's in DA Appendix 3, DA Appendix 3, 1007.
Sorry, could I
MS,
have the MS
yes,
number
5518, my lord.
5518, thank you so much.
point was made by my learned friend yesterday that, well, there were only 15 members of the House sitting in this committee, therefore how can that be seen to be the will of Parliament? Well, that's the way Parliament operates at the second bill stage, is that you have a committee which scrutinises the legislation. To the extent that one can divine the will of Parliament or the understanding of Parliament, this is just as relevant as a debate on the floor of the House. The amendment failed. Now, the amendment we see on its face at the bottom of the page, which is to do with regulations shall not be made in relation to persons responsible for a care of a child aged below 2, but it is absolutely clear that the thrust of this amendment was to deal with lone parents.
Well, there were certainly comments by Ms. Thornbury about lone parents,
yes,
but it was a much more ambitious attempt to secure an exemption, wasn't it, Mr. Sheldon?
Well, it's
because it covered two parents.
Yes, it covers two parents, but the purpose of it from Ms. Thornbury, who is making the amendment, is essentially to deal with the single parent
She did
position.
comment on that, but
yes,
when people came to vote, they had to look at the width of the proposal.
Yes. My Lord, it was presented, I say, as as dealing with the single parent situation. We can see that at 5529, halfway down the page. The amendment would disapply the cap to single parents responsible for children under the age of 2, people with full-time caring responsibilities, and victims of domestic violence. That is what Ms. Thornbury was putting forward. Now, it may well be because one can ask the question about, because when one looks at the detriment, the financial impact, as I said earlier, the financial impact on couples with children is actually harder than it is on lone parents, because they are capped at the same amount, but they have one more person to feed and one more body to clothe. So if one is seeking to address the issue of impact and to take into account the issue of should responsible parents be allowed to stay at home with their child under the age of 2, this covers it. But in any event, that was the thrust of the amendment was about lone parents. It's one matter that I ask you to take into account. We also know from, and it's set out in our case, is that the House of Commons Public Bill Committee considered representations for a number of organisations concerning the impact of the benefit cap upon lone parents with young children. There were representations made by a number of different groups, including groups whose evidence you have seen or you're going to be asked to see in these proceedings, where they talked about the impact on lone parents, the hardships that they were suffering under the cap, the difficulties in obtaining childcare, and so forth, barriers to work. I'm not going to take you to that material, but it's set out in our case. But again, it shows that material was understood and was taken into account by those who are decision makers in this case. That's the House of Commons. In the House of Lords, there were debates about this throughout 2015 and 2016, and there were, again, a number of amendments made, or a number of amendments put forward, in particular, an amendment to exclude women in late pregnancy and responsible carers of children under 9 months from the cap. The amendment was withdrawn, but the DHP guidance was updated to make that category, lone parents, women in late pregnancy and responsible carers of children under 9 months, one of the specific groups for whom local authorities should bear in mind when they're allocating DHPs. There was an amendment to exclude claimants of income support from the cap, during which the position of lone parents with children under 2 was particularly scrutinised. This amendment was rejected. And the point, again, to make from that is Parliament was aware of particular issues being raised about lone parents with children under 2, whether from the Thornbury Amendment and the discussion on it or through the House of Lords. But there was no decision made to make an amendment to give that exception. There was also an amendment to exclude child-related benefits from the cap. And again, that entailed detailed consideration or particular consideration of the position of lone parents with children under 2. There was also reference to the Article 3 of the United Nations Convention on the Rights of the Child. Various comments made by government ministers are set out in our case, including that of Lord Freud, who was speaking for the government in the House of Lords. But what we take from that, I say, is that Parliament was aware of concerns around lone parents. It was aware of concerns around lone parents with children under 2, and yet did not make amendments, did not seek to amend the bill in any way, or did not succeed in amending the bill in any way in those respects. The secondary legislation, so the regulations, were themselves subject to parliamentary consideration and detailed scrutiny. So the Act comes in, the Act is made, and then there is, which is when you get to see the impact assessment of August 2016, my Lord, and then there's discussion on the regulations, which are made on the 12th of September, laid on the 15th of September, and there is a series of debates around them and scrutiny around them. For the purposes of the regulations, the draft regulations, we have an equality analysis, and that we can find in DS Appendix 2, 449, MS 6374, 6374. I may be wrong on that. I think I've given you... Yeah. Oh, it's a different... sorry. Appendix 5.
6374 is right.
Yes, yep. That is right. I'm apologising to those with hard copies. It's in DA Appendix, Part 5. I do apologise.
1863 for the...
My Lord, thank you. 1863.
Yeah.
This document, we can see from 6386, 1875, is written in September 2016. I believe it was published on the 6th of October 2016. But as it says on its face, it records the equality analysis undertaken by the department to enable ministers to fulfil the requirements placed on them by the public sector equality duty. And I remind you, there is no challenge in this court, and there was no challenge below, that the regulations were made in breach of Section 149 of the Equality Act. But this was the document that the government produced to record its understanding and its analysis of the equality issues. Taking the first page, There's a reference to the duties under the Section 149 of the 2010 Act, and then there's the reference to the United Nations Convention on the Rights of the Child, and including Article 3, Article 26 and Article 27. There are references to the brief outline of the policy, what are the changes. Page 6376, so 1865, there's the rationale for the change. Aims to, and language that you will have seen earlier, but it strengthen work incentives, achieve fairness, ensure there is a reasonable safety net of support for the most vulnerable. It refers to the evaluation and the 41% proportionate figure. A lower cap recognises that many working families earn less than median earnings. A lower cap provides a strong work incentive. So that's the fairness comparison and fairness link, and then also the incentive link. And then it talks about the tiered approach. Then there's the evidence and analysis at 1866, which talks about the amount of the effect of the cap will be around £60 a week on average, median reduction of £49 a week, so it's well known what that is. And then it talks about the numbers who are likely to be affected of households. And then it refers at 1867, around half of the newly affected households will face a reduction of £50 a week or less. Of all the households affected by the lower cap, it is expected that around 22% will be couples with children, 63% lone parents, and 63% single couples with no children. So focuses on lone parents, identifies the households of lone parents. Then there's a discussion on gender. The language, most of the single women affected are likely to be lone parents. This is because we expect the majority of households affected by the policy to have children. Around 61% are estimated to be female lone parents. From March to May, the female employment rate was at 69%. There were 14.83 million women in work. Estimates also show there were 1.2 odd million lone parents in employment in October to December 2015. Then it talked about the benefit cap evaluation previously, and where it took you to that in the evaluation. Over 16% of lone parents in scope had moved into employment after a year, compared to less than 10% under the cap. If lone parents cap responded similarly to those assessed as part of the previous benefit cap evaluation, we would expect to see lone parents impacted by the cap being 51% more likely to go into work than similar lone parents who fall just below the cap's level. So basing themselves on the previous evaluation, predicting the future, analysing what is likely to happen. And then they have a reference to current published statistics show that 16%, 3,240 of currently capped households have a child under one. Of these, 2,240 are lone parents with a child under one. When considering the impact of the new lower tiered cap, if similar proportions are seen under the new cap, then the number of households affected with a child under one would increase. So specific reference on the face of the document to lone parents with child under one. But you'll see there's a footnote there, footnote 6, which refers to a document at the bottom of the page. And we have we've had that document handed up to you, because it was, and it should have been provided to all my learned friends. This was a document that was before Mr. Justice Collins in the High Court. I'm not sure why it didn't make it into the bundle, but I noticed it when preparing these submissions. Because it is said by Mr. Wise against me, well, look, the EIA didn't even mention lone parents for children under 2, but they are referred to in the footnoted document.
It's this.
This is this document, my lady. Yes, it's a separate document.
It
My
arrived
Lord,
this morning, yes.
don't have it, then I think that we have more copies.
One of these.
This document,
Here we go.
my Lord, we have further copies if you don't. Yes,
This is the one which has 74% in a circle.
Yes,
Yeah.
my Lord, that is correct. So this is a published document, the official statistics produced by the DWP, dealing with the benefit cap. And if you can see page 4 of this document where the capped households are. You can see under 5 the family makeup of capped households. 2/3 of capped households are single-parent families. This is page 5. 78%, 10,400 of single-parent capped households have at least one child aged under 5, including 17%. 2,200 with a child aged under 1 year at May 2016. And you can see from the graph, from the table, the bar chart, that's it. The bar chart.
Yes, we've been referring to graphs which weren't graphs at all. Yes, never mind.
Bar chart.
Pretty pictures.
You can see there how many children are under the age of 2. You can see the 0, you can see 1, 2, 3 and 4, etc. The age of the youngest child. So all of the different cohorts are identified there. And then it's also referenced that 61% of capped households had between 1 and 4 children, and 33% had 5 or more children. Child benefit and child tax credits are both in scope for the benefit cap, so families with more children in receipt of higher amounts of these benefits are more likely to exceed the cap limit and be capped. That's picking up the point that I made at the outset, that the financial impact is more likely to be affected by those with larger families. The more children you have, the more of those benefits that you receive, pre-cap. And then over the page, you see the various benefits that have been claimed by capped households. Then you have at page 7 the financial impact of being capped. And you can see there that the vast majority of those who are capped by less than £50. And then you have at page 8, moving off the cap, 41% of households that were capped are in work. So there was analysis provided, there was an awareness of how many under 2s. Then returning to the EIA, the equality analysis at page MS 6378, 1867 in your hard copy, the last paragraph. Lone parents may find it harder to find work due to childcare responsibilities than those without children. However, mitigations, particularly supportive to women and lone parents, have been put in place, including employment support, support for childcare costs, free childcare places, and discretionary housing payments. So a recognition of lone parents in particular, and then a recognition of they may find it harder to find work, so no avoiding that issue, a full awareness of it, but what's been done to try and mitigate. And then, if I turn to 6382, 1871 in the hard copy, this is in the context of life chances and impacts on children, so a specific focus on children. The benefit cap is supportive of the life chances legislation and of the best interest of children, because this policy gives the incentive for people to make the choice to move into work. It is a choice to move into work. There is not a compulsion to move into work. It has been suggested by Mr. Drabble that essentially there is a sanction, there is a punishment by the cap. We disagree with that characterisation. We say it's wrong. And no one is compelled to work. They are encouraged to work via the cap, and they make a choice as to whether or not to do so. And then it says, for those children whose parents do not respond positively to the cap, in other words, do not move into work, they may be adversely impacted with less household income, which may lead to potentially cutting back expenditure or changing location and maybe schools. However, findings from the evaluation of the current cap suggest that the benefit cap has not led to significant increases in the proportion of capped households moving house, and of those moving house, the majority move within the same local authority. So an awareness, an identification of what happens if the parents do not move into work? What happens if they don't move into work? What is going to be the impact? Well, actually, it will depend on how the parents respond. They may respond by there being a cutting back of expenditure as a result of the adverse impact of having less household income. So, an awareness of that, an identification of that, having picked up the same point from the qualitative analysis that I took you to before, the qualitative evaluation of the old cap. That's what people were saying had happened to them under the original cap. Here is a recognition and an identification that what may happen depending on the choice that a parent makes. But it says, in spite of that, even if parents don't make the choice. However, the current cap has been shown to be successful, with more households looking for and finding work, and I showed you the evaluation to support that. The new lower tiered cap aims to build on the success by strengthening the work incentive for households. In this way, the number of children living in workless households could fall over time, which is in their best interests. That's the judgment of the government. It is not in the best interest of children to live in workless households. Children can have their life chances and opportunities damaged as a result of living in households where no one has worked for years and where no one considers work is an option. You'll see some of the same points that we've seen earlier in the impact assessment, and there's some additional points as well. But this is a document which recognises that not everyone is going to respond to the cap. It talks about the mitigation measures that have been put in place in terms of childcare support, and then it explains that there may be adverse impacts in terms of household expenditure and cutting back on expenditure. And then over the page, the mitigations detailed below are particularly supportive to parents, which in turn will have a positive impact on their children and include employment support, support for childcare costs, free childcare places, and discretionary housing payments. So, and we'll come on to this when we look at Article 3, even assuming, and that's my primary position, is it's not something that you should be taking into account, but even assuming that it should be taken into account, here is the government expressing its judgment as to the best interests of children, but recognising that there will be a cohort of children who are specifically affected by the cap where their parents do not choose to move into work or cannot move into work. And if they can't move into work because of barriers, they have put in place mitigation measures to encourage and incentivise parents to move into work, which include the childcare costs. And we see at the bottom of 6383, 1872, the same kind of language that we've had in previous documents. I won't take you to that again, but it recognises the childcare costs through working tax credit and universal credit, and then it talks about the free childcare, 15 hours, and then moving up to 30 hours for 3 and 4 year olds, who, whether or not you're in work or not. Sorry, no, for working parents. For the disadvantaged 2 year olds, it's 15 hours of free childcare. Working parents, 30 hours a week of free childcare. Then they refer to different exemptions, and then there's a reference to the discretionary housing payments. And we know from all the cases in front of you, all of the appellants, from what they have said in their evidence, they've all been in receipt of DHPs.
Is there any analysis as to the uniformity with which those payments are made by the various local authorities?
There is an analysis as to how many, what they've, how much of the DHPs have they taken up? How much have they used?
No, because they haven't taken up their full allocation. My question was whether although I know there's guidance, but we read that it's discretionary.
Yes.
And I just wondered whether there was any evidence in either of these cases about the uniformity with which different local authorities make payments to people who are thought to
My Lord, there were many documents in the bundle about DHPs. I will see if there is a particular document which responds to that. In summary, based on the materials that I've taken you through so far, we say careful thought was given by Parliament and then by government when making the regulations to the impacts of the cap. Consideration of the best interests of children, I submit, is a thread which runs right through the thinking about and objectives for the benefit cap. The positive benefits of parents moving into work, increasing incentives for them to move into work, whilst also acknowledging that if parents do not respond positively, they may be adversely affected, and the amount by which they can be adversely affected is given by the figures. But what this will mean for any particular family will obviously depend case by case. It cannot be comprehensively analysed, because every family will be in a different circumstance, and they will respond in different ways. But you've been urged by the appellants to intervene in this case and find unlawfulness on the basis that Parliament and government has not addressed its mind to the key aspects of the dispute. That, I say, is wrong. There is plenty of material, there were plenty of opportunities for Parliament and then for government to think through the different issues, but they arrived at a conclusion which is to have the cap in the way that it was, in spite of the impacts that it might have on those who are impacted, on those where the parents do not respond in the way that the government is seeking to encourage. The government has also been criticised by the appellants for failing to carry out an analysis of impact by reference to relative poverty or by reference to some other definition of need. Firstly, we say there is no legal obligation for Parliament or government to do so, and I'll deal with that in our legal submissions. It's certainly not part of domestic law as currently understood. It could only come through the Article 3 of the UNCRC, and I'll seek to argue why that doesn't apply here or why it's not necessary here. But please bear in mind, as I said at the outset, there is no case here about destitution. It is not alleged that there is destitution as a result of the benefit cap. There is no allegation around Article 3 or 8 of the Convention. There is no argument that relative poverty, which is forms much of the analysis provided by Shelter through witness statements of Graham, Brown and Polly Neat. They talk about relative poverty and the different measures that there are, but they do not argue that relative poverty amounts to destitution. Relative poverty, there are a number of different measures which are essentially based on percentages of median or average household earnings, so it's a relative to other people, but they do not contend that that amounts to destitution if one is in relative poverty.
What significance does destitution have? You're not suggesting, are you, that for a breach of Article 8 to be established that it needs to be shown that you're reduced to a position of destitution?
My Lord, if the argument is there is a breach of Article 8, not looking at discrimination, a breach of Article 8, then it needs to be a finding of destitution.
Well, that's based on what Lord Dyson said, but apart from what he has said, is there any principled basis for saying that?
Well, there's the Anna Frajeva case, which I can take you to, which makes that very point, that it is Article 8, they say, is unlikely, because there was, first of all, there was no positive obligation generally on any of the signatories to the convention to provide welfare benefits. There will be a positive obligation to provide welfare benefits in very severe circumstances, and there are a number of cases where that's been done. There is no case where there is a requirement from Strasbourg that a state needs to provide a whole welfare system or a welfare system at a particular level. And what is said in Anafrageva is that the severity of the situation is to amount to a breach of Article 8 is one which would essentially be a breach of Article 3, which is inhuman and degrading treatment. And that's what we're talking about here. To use the language of my lady Baroness Hale in SG, where she talks about basic necessities of life, that we say is the same as that's destitution. That's how I'm using it. If one is deprived, because there's language in SG, I think it's paragraph 184, where it is said that the level at which the previous cap was set would deprive children of the basic necessities of life, and it talks about adequate clothing, food, and housing. That is a destitution level.
Well, I didn't mean destitution then. I meant subsistence.
Or subsistence.
Subsistence is different.
Or subsistence. Well, this, again, it's not alleged that this is a subsistence level. It's not said there's a breach of subsistence level.
Well, surely it is. Because the whole point is that means-tested benefits are set at subsistence level.
Well, my lady, that's
as defined by, officially defined. Now, obviously, you can define it in many different ways, but as officially defined, that's what means-tested benefits are set at.
My lady,
and the whole object of the cap is to reduce that.
My lady, there is no... That is not the way in which benefits are decided upon, and the amounts of benefits are decided upon. They're not based on an assessment of is this subsistence or not. And when one combines them, it's certainly not based on subsistence. But in any event, there is no legal obligation. There's no legal obligation to provide a subsistence level. And none has been pointed to. We say you have lots of evidence from Shelter about the sort of the global picture. And of course, you will look at that and analyse it. But what it does is it doesn't include a number of relevant variables that affect the impact of the cap. It doesn't, for instance, include the discretionary housing payments that all of these claimants have received. It doesn't include child maintenance, which many of these claimants have received and which is not caught by the cap. It doesn't include working a few hours, even if one doesn't come off the cap. Working a few hours can actually bridge the difference between what you were receiving previously and what you were receiving under the cap.
So are earnings from working a few hours disregarded for the purpose of means-tested benefit?
Well, what happens is the first £20 is not disregarded from the calculation of the benefit. And then if you are over the cap, it doesn't matter, in a sense, that any disregard will just be caught by the cap in terms of your benefit was already more than the cap and couldn't be reduced lower than the cap. So the effect of that is you can keep the extra earnings that you have. And Mr. Edson refers to that in his witness evidence. So working...
I'm not sure that's accepted by the other side. It may or may not be. We will...
Well, that's the way the system operates. If your let's assume your overall benefit level is £570, and of £70 out of that is income support. That income support, if you earn £20, income support doesn't get reduced at all. So you can keep the £20 and you can keep the cap, which is £430, let's say. If you earn anything more than £20, yes, your income support is reduced, but you're still over the cap. And therefore, it makes no difference to the amount of benefit that you receive. So yes, it is taken out of income support, but because you're over the cap anyway, you can keep that money as earnings without it impacting on your overall benefit receipt. It would have impacted under the previous system before the cap, because it doesn't apply to some of the other benefits. It doesn't apply to the child benefits, for instance, or the child tax credits, for instance. You still receive those even if you're earning less than the working tax credit amount or number of hours. So you could work, and Mr. Edson explains that, you can work several hours at national minimum wage and basically make up the difference between the cap. That's not taken into account in Shelter's evidence. Their analysis is also based on private sector rentals, whereas in fact, most of those who are capped, 58%, are in the socially rented sector. And their analysis is also based on the 30 percentile of housing benefit rates, whereas of course there'll be many people who will be in houses where rents are less than that. There are so many variables that they haven't taken into account that it calls into question the adequacy of that analysis. Because actually, assessing the real impact of the cap can't be done on a general basis because there are so many individual circumstances. However, even if you accept all of their assumptions and just take it at face value, we say that the DS claimants, and you may remember you were taken to a table which showed what the DS claimants may have earned if they weren't capped, what they could receive if they weren't capped. There were two graphs. We say that looking at Shelter's analysis based on what they call essential living costs, which one might use as a proxy for subsistence, the basic amounts that people spend on essentials. Even taking that, even assuming that, the DS claimants, even though they are subject to the cap, receive more in benefit than what Shelter say are the essential living costs. And I think we have a, I can show you graphically how that works.
So could I note again that the proposition that this paper is going to show is?
This proposition is going to show, on Shelter put in evidence, which says one of the poverty measures that they use is essential living costs. And they work out a basket of goods, which they say are essentially subsistence. And they show how much does a family of different numbers of children need after their rent is paid to have essential living costs made out. And we can see from the DS claimants that even on that analysis, even accepting all the variables, the two DS appellants have greater amounts after paying their rent than are needed to pay for the essential living costs.
Let's be clear, Sharon, what you're expecting us to do with this. I mean, obviously there's a disagreement between you and Shelter about this.
Well, there may not be a disagreement at all about this because this is based on their figures.
No, the point is that these are their figures.
There may be disagreement as to what it means.
Well, and they may well come back and say, well, actually, you've misunderstood them. And
well, we based it on...
Where do we go? I mean, this is what's worrying me.
Yes.
We're being asked to resolve quite complex factual issues about how these things work, faced with your evidence from a very authoritative department, but also from two very authoritative charities. If at the end of the day we think they're probably right, but where does that leave us?
Well, the test that you are, assuming we get to justification, The test that the court will need to ask itself is whether or not it's manifestly without reasonable foundation for the for Parliament and then for government to have introduced this legislation in spite of its discriminatory effects.
Yeah, but on these
cohorts.
factual issues...
Yep. Well, on the factual issue, unless you conclude that the Secretary of State's analysis was essentially manifestly without reasonable foundation, then you can't find that there's been a breach of Article 14. And, but the point about essential, what we're saying here is they've carried out an analysis using different poverty figures.
Yeah.
The Secretary of State says one doesn't need to do that to satisfy her convention obligations. But let's look at the evidence that we've got, because that's, if the Secretary of State had done the thing that they had done, because the complaint is, well, we didn't do this.
No,
Well, now,
All right, anyway,
now they are doing this. Well, what this paperwork shows, and it's based on the, I say, on their evidence, and we can just pick it up in interveners bundle, if I can find that one. Interveners bundle, thank you, tab 8, page 23. It's the second witness statement of Polly Neat, which is at 10.536. And we had this evidence below, although it came from a different witness, and it was slightly different figures, but not materially different for our purposes. You see at the bottom of that page, 10.536, table 3, weekly residual income needed after paying housing costs for essential family costs. And if you look at paragraph 52, that's where they set out what the essential family costs are. Utilities, food and non-alcoholic drinks, personal care items, cleaning and maintenance products, clothes and footwear, transport, communications, and so on. And they say this is what these families need to live on depending on the number of children. One parent family needs to have different amounts to meet those costs. And you can see it increases with the number of children. Obviously, it's got nothing to do with the age of the child. It's to do with the number of children. When one looks at the evidence of DS, and I won't take you to that, but you can. This is just taking it from her evidence as to what she's capped at, which is the 384 figure because she's living outside of London, and what her rent is, which is £111 a week. So what does she have left after paying rent is £273. She has 5 children. That is, she therefore has left for her more, almost £40 more than what Shelter has described as essential living costs. And that's before one even takes into account discretionary housing payments or any other payments that she may have received. In fact, I think she received child maintenance of several £100s a month. And with NL, the other appellant in the DS case, she has 4 children. She's also capped at 384. Her rent is £115. What does she have left? It's £269. Very simple calculations. She has 4 children. On their calculation, she would need £206. She has £62 more than to meet essential living costs. So when the government says that the cap is set at amount which is enough for people to live on, that is adequate, that they're protecting the most vulnerable, this evidence supports that. So the government wasn't wrong to analyse it in that way. And of course, DHPs will come in when there are hard cases in particular circumstances. And there are, as I've said, other payments that can be made. So this, we say, comes into the analysis of what is the detriment of the cap? What do people have to live on? Have they been pushed into subsistence or destitution? And you weigh that up against the policy objectives. And we say, of course, when you get to that analysis, the government haven't acted manifestly without reasonable foundation. But there are some other aspects of the poly-neat evidence which is worth looking at. If we look at page 10537, page 24, she has another table, the proportion of England where the cap would leave a one-parent family without enough to cover their rent and essential family costs. That is based on the 30, basically having rent at the 30 percentile. So there will be many people who actually rent at less than that. But that's the calculation that they're using. And what is shown by this, because this is their case to say you can't escape the cap by moving around the country. You can actually see that it all depends on how many children you have. If you have 2 children, this is using their figures and assuming that all their variables are right and assuming that DHPs aren't in play and you don't receive any other income from anything else. Actually, with 2 children, 93%, you can live in 93% of the country and have enough to live on to meet your essential living costs, even if you're capped. 68% with 3 children of the country, 57% with 4 children, 15% with 5 children. And the reason why I'm seeking to show you this is because the case that's being made by DS is that the cap should not apply at all to lone parents, because essentially it's saying it's putting the entire cohort, or too many of the cohort, into extreme poverty or in a situation which can't be justified. But actually, these statistics show that one cannot and should not be taking that broad brush approach. The government has instituted a policy whereby, for hard cases, DHPs will be made available. So in those areas where you can't meet your essential living costs, you can't reduce your rent, or your rent is at these levels, the 30% level or above, that's the kind of situation where a DHP would apply. Or that's where you could expect to get DHP unless you're getting income elsewhere, you've worked a couple of hours, or you get child maintenance. But the statistics do not support, we say, in fact they go the opposite, that there should be an exemption, essentially, for all lone parents. Or lone parents with children under the age of 5 or under the age of 2. Because what this shows, it's got nothing to do with the age of children, what the impact is on you, where you can live without essential living costs. It's how many children you have. So, in summary, our use of their evidence is, well, we didn't do that analysis and we're criticised for not doing so. We say we're not obliged to do so, that in fact it's not necessarily, it's not unreasonable not to do so, given how many variables there are, and it all depends so much on the circumstances. But even had we done it, so now looking back retrospectively, it can be seen that the cap does not put people throughout the country, however many children, if they're lone parents, it doesn't put all people around the country, or even the majority of people around the country, into a subsistence or destitution level. And so, in a sense, to conclude this section of my submissions, I remind you of the legal principle that Mr. Wise referred you to, which is Lord Bingham's observation in Countryside Alliance. The democratic process is liable to be subverted if, on a question of moral and political judgment, opponents of the Act achieve through the courts what they could not achieve in Parliament. That is exactly what the DA appellants and the DS appellants are seeking to do. And we say this court should be very, very careful when making its decision, when thinking about this matter, in that context. Amendments were made or put forward, sorry, they weren't made, amendments were put forward or withdrawn around these areas. They didn't get through Parliament what they were seeking, coming to the courts to try and achieve the same thing. The court should be very, very careful on a matter of what is really a political judgment as to what the level of welfare benefits should be and who it should be applied to. If they can achieve through the courts what they couldn't achieve in Parliament. So those are the background materials, and I'm going to move on as quickly as I can through the legal issues and then move on to justification. Much of what I want to say and what the Secretary of State wants to say about the law is set out in our case, and I'm not going to take you to that in any detail. We simply don't have time, although I'm obviously happy to take any questions that you have on anything that we've put there. But I want to look at what is the discrimination that's being alleged as conceptually. Well, the simple point is we can all agree on this case is about Article 14. And in the context of Article 14, the preliminary questions that the court will ask is what's being complained about within the ambit of one of the convention rights? Is there discrimination in the enjoyment of the convention rights? And then there's the question of status. Now, we have dealt with that extensively in our case, where we essentially disagree as a matter of law, and then also application to the facts, with the approach taken by the appellants and by the EHRC, and we set that out between paragraphs 87 to 114. In a nutshell, we say that there's no status for the different cohorts that are being put forward. We also say, and if there is a status, it has to be at the margins of in the furthest of the concentric circles that Lord Walker referred to, which means that there's less that needs to be justified, or less weighty reasons to justify. And in terms of ambit, we say, firstly, the child claimants cannot come within the ambit of A1P1. I've already made that point earlier. But also we say they can't fall within the ambit of Article 8. And we say the same for the adult claimants. Yet they can come within A1P1, we accept that, but not within Article 8. And we explain why in our case.
In your case, you refer to some observations of mine in the SG case and also of Lord Hughes about this. We weren't referred in SG, as far as I can recollect, to Petrovich and the later line of authorities that followed from it.
I can't recall if you were referred to Petrovich, but we deal with Petrovich and, if I can get the name right, Okpish in our case. And we essentially talk about they're very different situations from ours, in that they're dealing with in terms of impact and in terms of intention. And we seek to distinguish those cases in the way we set out in the case. But even if, but I ask you to read between 87 to 114, and we don't resolve from anything that we've said there.
I take it the government's position is that the approach which Lord Bingham and Lord Nichols took in M hasn't been, I wouldn't say overruled, but hasn't been superseded by the Petrovich and other cases. Yes.
And Clift, we talk about it in terms of Clift. Yes, we say that is still the approach that this court should take.
But if there are positive measures which are a modality of the protected right, then questions about core and margin wouldn't arise.
My lord, we say that in those, that this is, our situation is to be distinguished from the positive modality cases that you probably have in mind, which are the Petrovich and Opkis type of case where there is a specific benefit that is being paid for a specific purpose. That's not what's being done by the cap. What the cap is doing is it's setting a maximum amount of benefit which might or might not impact on a particular benefit, because that's not the way in which it's being looked at. It's not being looked at, let's take away some child benefit. It's saying this is the overall benefit being reduced via housing benefit. And there is a difference, we say, between a reduction of a benefit and an absolute prohibition or refusal to pay a benefit, which is exactly what you had in Petrovich and Opkish, and then in your more recent decision in Steinfeld, dealing with civil partnerships.
Yes. So you would not treat housing benefit, which is subject to reduction, as a modality of respect for Article 8 rights?
Well, because it doesn't have to, one is not being refused housing benefit, one is having a reduction in housing benefit. And in Carmichael, where the matter seemed to have been accepted by the Supreme Court, there's no discussion, there's no reasoning there. The particular case was concerned with the specific housing situation of an individual.
Yes, but whether it's reduction or removal, we're not concerned here with a breach of the article. We're concerned with the we're concerned where a state has given a benefit which shows its respect for family life. We're concerned to ensure that there's not discrimination in the handling of that benefit.
My Lord, the language, I think, is of an avowed infringement, and we say there isn't there still has to be an avowed infringement, even on the court's analysis. That's what is said in Steinfeld. I see the basis on which you attempt to distinguish Petrovich and Okpish is to focus on the cap and the objectives of the cap. And you say the objectives of the cap are really nothing to do with the aims of Article 8. It might be said against you, but what we should be focusing on is the objective of the benefit, which is being capped. For example, housing benefit is obviously related to Article 8 objectives, and child benefit, the same might be said. Well, my Lord, you have our submissions, and I don't want to spend any more time on this because there's a lot more that I need to deal with.
You've got a lot to cover still.
I've got a lot to cover. If you're not with me on ambit and status, then we need to consider what is the discrimination that's being put forward. You heard yesterday from Ms. Mountfield on behalf of the EHRC that essentially one doesn't really need to look to see whether or not it's direct or indirect or flimenos discrimination. And there was an attempt really to elide all the concepts as to be one kind of discrimination. The difficulty with that approach, which we say is not consistent with the case law of Strasbourg, or certainly not of this of domestic courts, is that this makes it impossible for the court to know what it is that's being challenged and what needs to be justified. And you have an explication of that by Lord Justice Laws in first instance in the MA case, which we set out in our case at paragraph 120. MS 8421. Lord Justice Laws says there, so it's page 63 of our case, 8421. He was considering the relationship between the three types of discrimination. It was cited in DA by the Court of Appeal. The difference between direct and indirect discrimination in flimenos retains a conceptual importance because it will determine what it is that must be justified. Where the treatment is direct, it's the rule itself that must be justified, the difference in treatment. Whether discrimination is indirect, it is the disparate impact that has to be justified. With flimenos, what must be justified is the failure to make a different rule for those adversely affected. So I do urge on the court to retain the conceptual differences between the different forms of discrimination. Second point to make on this is that it's notable that DS it appears to us to have resiled from alleging direct discrimination. This was an allegation which appeared for the first time in their written case, didn't feature in their claim or in the in any other materials that we had seen, but it does appear now that they are not pursuing that point. But we did address it head on in our case. They had argued that there was a targeting of lone parents, and they'd argued that there was less favourable treatment of lone parents. We suggested that that was completely wrong between paragraphs 123 and 130, but as they're not appear to be advancing it, I'm not going to spend any more time on that. If the case is brought as an indirect discrimination case, which is that there is a disproportionate effect of a particular measure on a protected group, something where it falls within status, what does need to be justified is the measure itself. And when looking at the fair balance, the detriment to the disadvantaged group has to be weighed against the other factors. So one has to justify the measure, and in the fair balance process, one considers the detriment to the disadvantaged group and weigh that against the other factors. We say, coming onto it, that it's only if that fair balance, having been conducted, is not manifested without reasonable foundation, that you can find a breach. For thlimenos, there must be a significant difference. I think Mr. Wise was saying it should be not insignificant. Well, that's not the language of thlimenos. The language of thlimenos was significant difference. Because if it's not significant, and you treat people differently who are not actually different, that is unfair. Significant isn't a question of necessarily of quantitative analysis, but is there enough of a difference to raise a prima facie case for an exemption? That's how we would put it. And there is a good reason for a significance requirement, which was set out in the DA case by Sir Patrick Elias, which you find in the core volume. I think it's at paragraph 106, which is MS 4549. It's actually 4550 at the top, where Sir Patrick says, underlying a thlimenos type complaint is the notion that different cases must be treated differently, but if the circumstances are not obviously significantly different, to make an exception for the group risks infringing the principle that like cases should be treated alike. That constitutes an unfairness and creates a sense of grievance in those whose circumstances are not materially different and yet are not treated in a more favourable way. It will necessarily be a matter of judgment in any case whether the circumstances are sufficiently different to warrant different treatment. The question in substance is, was it clearly unfair not to exempt them from the rule? And in the thlimenos type situation, what needs to be justified is the failure to make an exemption. And just to pick up on a point that Lord Reid said yesterday in terms of what was said about virtual impossibility, Sir Patrick Elias was not factoring into his test virtual impossibility. That was in response to findings of the court below. But in the judgment in DA, and that's the majority judgment, which is being appealed, Sir Patrick Elias addressed this question of significant difference, but Mr. Wise, in his submissions yesterday, did not deal with it at all. We refer to this in our case at 161 to 162. And it's important to consider that. MS 434. And picking up what the Court of Appeal said at paragraph 105, this is what Sir Patrick Elias said, there is no linear relationship between the financial impact on families caused by the cap and the age of the children. The financial impact or consequence of the cap will instead depend on how many people that household contains. You've seen that from the shelter statistics. Households with a greater number of children will typically suffer more, whatever the age of the children, simply because the parent or parents have more mouths to feed and are likely to need larger accommodation. Similarly, households with 2 parents will be worse off than households with single parents. We say that's a point of considerable importance to the Thlimenos claim. The vast majority of the criticisms made of the cap by the judge at first instance, and indeed by the DA appellants in their evidence, centred around the financial impact of the cap on families already in or close to poverty. The age of the child bears no relation to whether a household is in poverty. None of these criticisms are relevant to the question at issue. As the Court of Appeal observed in DA, the difficulties of establishing a Thlimenos case are compounded in circumstances where, even putting the case at its highest, only some of the cohort are prejudiced as a result of the alleged difficulties. In Thlimenos, one could see that all Jehovah's Witnesses or Quakers or whoever it is who is refusing military service will be subject to the rule that they can't become an accountant in Greece, or that was the rule. But in this case, not all of the lone parents with children under 2 are affected by the cap. Firstly, there are many lone parents with children under 2 who are not receiving benefits. Those who are receiving benefits will not necessarily be capped because a very large proportion of them, a big proportion of them, are actually in work and are doing more than 16 hours of work. Secondly, we point out at paragraph 163, the ability to obtain work will depend on a range of factors, many of which are wholly unrelated to the age of the children. And this is what Sir Patrick Lyse says. Such factors will include the availability of work in the locality for someone with the individual skills, whether there's help available with childcare from family or friends, perhaps through a sharing arrangement, the number of children the lone parent has and their ages, the complexity of any care arrangements, and the difficulty in getting to work which is available. So we say it would be, and why Thlimenos doesn't apply here, is that essentially it would be arbitrary to be creating an exemption based on the age of the youngest child where there is no direct correlation with financial impact at all, and where it is a subsidiary factor for the ease of work. And it would be particularly arbitrary here when you consider lone parents in the next kind of age range, the 3 to 5, what's known as the preschools, who make up 32% of the cohort, a very large percentage. You can't just ignore this when considering whether or not one is even into a prima facie case of Thlimenos discrimination. And it's in this context, my Lord, especially my Lord Hughes, who's expressed some concerns about this, where the absence of free childcare for the under 2s has to be seen. It is correct that children under 2 don't get free childcare. But the Court of Appeal looked at this and they said, at paragraph 110, this is that those matters, that childcare availability or childcare costs, do not go to the ability to obtain work, but rather to the financial benefit of undertaking it. And to the extent that they do, because parents are making a decision whether to go into work based on what's the financial benefit of doing work. But even if there is a factor, as I've explained before, there is a flexible support fund which makes funding available to people in advance of work so that they can plan to go into work and therefore kind of break the chicken and egg problem that Lord Hughes had identified. There's then the point around conditionality. My learned friend, Mr. Wise, took you to the conditionality regime. And as my Lord Hughes noted, there are actually various lines. There's a spectrum. And one of those lines is not 2 years old. It's between 1 and 3. And you can see that in our case where we deal with this at 243 to 246, MS 8462. The work-related conditions at 243, which attach to income support and job seekers allowance. First point we make, where the youngest child is between, this is to do with job seekers allowance and income support, which is the vast majority of people who are subject to the cap. Where the youngest child is between 1 and 3, the parent is required to undertake work-focused interviews every 6 months. The twos is not a dividing line. So we say that the Flimenos case for DA shouldn't get off the ground because there is no significant difference. We accept, of course, there are differences, but they're not significant, and not significant so as to lead to a court having to consider whether or not the difference in treatment or the treating them in a particular way when they shouldn't be treated in a particular way needs to be justified. We say the same applies if we are looking at the DS appellants, who are, one of their fallback positions is to look at lone parents with children under 5. What is the difference in reality between a child of 3 and 4, where 30 hours of childcare is provided free by the state, and going to school because of compulsory school age? In terms of the number of hours where in a sense, if we're looking at school as childcare, which I know it is not, but let's assume it means you're not having to care for your child during that time period, the hours at which you're at school are not that different from the 30 hours of free childcare. So we say there's no significant difference between the next cohort to justify a lone parent under 5 exemption, or rather to justify even having to go into the analysis of an exemption. And then their bigger case is to say, well, we should exempt the entire cohort of lone parents because they are significantly different from couples with children. Well, one has to look at this in a bigger perspective about what is the benefit cap. Because, as I've made this point already, the benefit cap actually impacts more harshly on couples than it does on lone parents in terms of the financial impact. The lone parent will receive the same amount of benefit as the couple, even though they have one less mouth to feed and body to clothe. On the other hand, the couple has an extra person to do work or provide the childcare. One can't look at one without the other. So there are, we say, positive and negative differences. But when one adds them together, they are not significant to invite you or to lead this court to have to look at, is there justified or unjustified discrimination? But let's assume that we are into justification territory. That I have to justify on behalf of the Secretary of State, or the Secretary of State has to justify through me the various measures.
I wonder if I could ask just the last comment. Are you saying that there is no such category, identifiable category as lone parents, or are you saying there are pluses and minuses and we need go no further?
Well, assume that there is a status of lone parent, and I'm arguing that there isn't. There is a status of women, which is the way the case was argued in SG, but not in terms of an exemption, but in terms of what we'd say more traditional indirect discrimination. Here I'm dealing with Slimenos. I would say lone parents is not a status, but even if it is a status, they have to be significantly different from someone else in an analogous circumstance, which is a couple.
I'm just testing the idea that there isn't a status in this context because you recognise in the legislation as one of the categories lone parents.
We do, but merely because there is a recognition in legislation of a category doesn't mean that there is, by definition, a significant difference. No. That's the way in which the claimants are trying to put the case, which is, look, you recognise the difference between 2s and 3s, or 2s and 1s in various bits of legislation. That is a factor. You have to accept that it is a factor for you to take into account, but it's not in itself determinative, especially when in the round, the impact on couples is actually greater than the impact on lone parents. So for the purposes of this legislation, and whether it can be justified, or whether it needs to be justified, we say we don't get there on Slimenos. On the indirect discrimination analysis, the DH and Czech Republic type case, which is a question of is there a disproportional prejudicial effect, we accept for lone parents as women that there is a disproportionate effect. We don't accept that they are a status for those purposes, but we don't accept that children of lone parents of any particular age are disproportionately prejudicially impacted. Who are they being contrasted with? You've looked at the statistics. Actually, the difference in terms of the numbers who are capped, in terms of lone parents with children under 2, and then the next cohorts up, are not materially different. They're very small percentage differences. I know you were looking at a table yesterday, but actually I think it's like 26% and 28%. Nothing, not between 2s and 3s, it's not materially different. So we say there is not there a sufficient difference in terms of disproportionate prejudicial effect to bring us into a requirement to justify. However, even if I'm wrong on all of those points and we need to get to justification, we say, of course, any of the discrimination, in a sense, the differential treatment or the non-differential treatment is justified. And it's justified on the basis of, we say, the 3 policy aims, whether you take them individually or cumulatively. And that is fairness, incentivization, and fiscal savings. But before we get to that, I do need to just deal with the issue of manifestly without reasonable foundation. I'll deal with that very briefly. We say it does apply to all stages of the analysis, including the final stage, the fair balance. We say that this court should defer to Parliament and to the government in respect of their particular piece of legislation on the basis of did they strike a fair balance in a way which was manifestly without reasonable foundation? That it's not a matter for the court itself to determine. We deal with that in our case between pages 188 to 201, paragraphs 188 to 201 in some great detail, MS 8442. And just to make a few highlighted points, this argument was run in Carmichael before a 7-judge court who rejected that there should be a departure from the manifestly without reasonable foundation test. They looked at the measure as a whole and they said that it wasn't manifestly without reasonable foundation as a whole, albeit there were aspects of the legislation which were manifestly without reasonable foundation. There is nothing to justify arguing this point again, and there's no basis, we say, to depart from that test. We accept that there are cases of this court where there has been an acceptance that manifestly without reasonable foundation doesn't apply to the final test, but they're not cases involving welfare benefits. They're not STEC-type cases. This is a STEC case.
Well, it's very odd, isn't it? Because STEC-based that. The footnote in STEC refers to James.
To James, yes.
And it was because of the reference to James and the subsequent A1P1 cases that did draw that distinction, that in the case which I tend to call asbestos,
Yes.
This court drew that distinction.
Yes. But one can see in asbestos, you're not dealing there with a welfare benefit case. This court, we say, should not move beyond Strasbourg on a matter like this without any indication from Strasbourg that in a welfare benefit case, they are going to move beyond a manifestly without reasonable foundation test to the entire proportionality analysis. There is no case.
Did you say that the test then, Mr. Sheldon, was, did Parliament strike a fair balance which was not manifestly without reasonable foundation?
I do, in terms of the...
Is that intellectually sustainable, that question? I mean, if it's fair, it's fair. How can there be any departure from that litmus paper test?
Because fairness, I would say there are degrees of fairness, and there are something, and there can be different interpretations about what is fair. It is not an objective test.
Thank you.
Especially when one is considering the issue of balance. Could one decision maker strike a balance reasonably in one place when another decision maker would strike it in a different place? That's what I'm asking you to apply as the test when one gets to that. And that is what STEC, we say, demands, and that's what this court has previously insisted upon in Humphreys and so forth.
STEC insists on the manifestly without reasonable foundation test.
Yes.
And that's been applied in Humphreys.
Yes.
But not with the gloss that you're putting on it to say that it's not for the court to make that judgment, giving, of course, the greatest possible weight to the judgment made by the primary decision maker.
I believe the court is making the judgment as to whether or not the measure is manifestly without reasonable foundation.
Yeah.
And
which includes, of course, the fair balance.
Which includes the fair balance. So the court has to ask itself, we say, that if one is going through the analysis in Tiger, the four-stage analysis, then at each of those stages, the court should apply the manifestly without reasonable foundation test, and not just for the first three, and then when it gets to the last one, say, well, we're going to decide this one ourselves. That we say is orthodox. That's the orthodox principle, and the asbestos case and I think it's an A and B are not in the same context, and there are reasons for that, good reasons for that, which are, I mean, first of all, Lord Toulson made this point in Carmichael. Choices about welfare systems. He says this. I think it's paragraph 32. I don't have the citation immediately, but Carmichael 32. Choices about welfare systems involve policy decisions on economic and social matters, which are preeminently matters for national authorities. That's the core, and that's the rationale for it. Good reason.
Well, one might have thought that the choice about saving money for the health service in Wales was about the allocation of national resources. And one might have thought that the use of the NHS in England was about national resources. It's quite difficult to see what the principal distinction is. It's all about
we
public money and how it's spent.
Yeah, and we say the answer to that should be that manifestly without reasonable foundation applies across the piece, where you're looking at issues of institutional...
That's why you've got seven of us together, so that we can say that asbestos and A and B were wrong.
Well, I think we've asked for seven together so that we can say don't apply those principles to the welfare system, because that's STEC. And if you're going to depart from Strasbourg, there needs to be seven judges of you to do that. But I caution you, or urge you not to do that. But of course, if in your analysis you are happy to row back from asbestos on A and B, but I'm not actually asking you to do that, then so be it. I don't need that for the purposes of my argument today. But we're looking at institutional competence and democratic accountability. And those reasons for themselves, we say, demand that they manifest without reasonable foundation test should apply. Carmichael, I'm reminded, is in Core Authorities Bundle 1, tab 10, MS 137.
MS?
MS 137, my lord.
Thank you.
It's then been put against us that, well, you can relax the manifestly without reasonable foundation test where the justification that you're now deploying wasn't something that you deployed originally, and there's reliance made on Brewster. Well, we are not relying on any different justification now than we did before Parliament, in Parliament, after Parliament. So the Brewster principle doesn't detract from what we say should be the appropriate deference. And also, we'd also remind the court that at paragraph 52 in Brewster, it is said, and no one on the other side of the table here took you to it, is even retrospective judgments are worthy of respect if made bona fide. And so even if we are taken to be making a retrospective judgment, there's nothing to suggest that we're not doing that bona fide, and therefore we're worthy of respect. As for the misbehaving argument, we say it's clear that Parliament and then the government took into account the various factors. You've seen it on the face of all the documents that I've taken you to, in terms of impact and difficulties of obtaining childcare and the other distinctions. So a fair balance, a balance was struck, taking into account the relevant factors. We say it was fair and not manifestly, reasonably foundation unfair or not fair. But moving on to the substance, because whatever the test is, the appellants say you have to accord proper respect to the decision maker. We say the legitimate aims apply to all of the cohorts that are bringing their cases before you. We say that all of the aims are legitimate. We say that all of the aims are rationally connected to the cohorts. And we say that either taken singly or cumulatively, they justify whatever discrimination it is that is in issue, whether indirect or they justify not making an exemption for the small cohort, the medium-sized cohort, or the big cohort. Looking at the legitimate aims, we have fairness as a legitimate aim, and we address that in our case between pages 202 and 229. It's described as promoting a fair and healthy society and maintaining public confidence in the welfare system by imposing a reasonable limit on the total amount which a household can receive in welfare benefits. We say the best articulation of that fairness objective was Lord Reed's in the SG case at paragraph 66.
I think he did better than you did, didn't he?
I think he did extremely well, and we're delighted to adopt it. But we say it was following on from our submissions, and but we say it was beautifully crafted. We say it applies similarly to this case. I took you to the language of all the different impact assessments. I've shown you the reference to the fact that the cap is publicly supported. I've referred to the relationship with the 4 in 10 households. The suggestion that the only fair approach is to base something on equivalence is just simply wrong. The same argument was made in SG and it failed. It was not part of the fairness test. It wasn't understood by anyone to be part of the fairness test, and there was no false understanding or false perception of what it was that was being done by the welfare cap. There's simply no evidence to suggest that the public, let alone Parliament, was not aware that those in work, many of the people in work, can receive considerable in-work benefits. Both of the interveners have actually ignored this aim in their analysis, and you heard Ms. Mountfield talking about, well, actually what the test is, it's the benefit cap is actually a 16-hour work requirement, as if work incentivisation was the only aim. That's just simply not right. Of course, it is a key aim, but it's not the only aim. The benefit cap is a reasonable limit on welfare benefits. That, we say, is the measure under challenge. It's not unlawful, we say, because not everyone can escape it. Why is it argued that this is not a reasonable aim, or is not a legitimate aim, or is not justified here? DS say, well, it assumes that the earnings figure is an appropriate indicator of what families receive in work. Well, that's just simply not right. They question, is this a sufficient amount to live on? Well, we say, as in, you can't be fair if what is left behind is not sufficient for someone to live on. Well, we say, first of all, the evidence doesn't support that. Secondly, there's no Article 3 or Article 8 claim here, or claim of a breach of Articles 26 and Articles 27. And in any event, it was a judgment call made by Parliament. It's on the face of the statute. And it is something which does leave sufficient to live on. And where it causes difficulties, particular difficulties, there is a regime for DHPs to be put in place to take care of that, as we've seen through the evidence of each of these appellants. In our case, at paragraph 213, we set out 5 questions, which we say are all matters of legitimate political debate. That's at paragraph 213, MS page 8452, all of which we say impact on what is fair here, but they're all matters of legitimate political debate, and they're not essentially addressed by the appellants or the interveners. Firstly, how should reducing income-related poverty or meeting income needs rank against other state priorities? So, how much do you provide in welfare benefits? What are your other priorities? How is poverty or need to be measured? To what extent is poverty to be tackled by paying benefits as opposed to other measures, focusing on causes rather than the symptoms? To what extent should the approach differ depending on whether the house is in work? How are short-term and long-term impacts to be balanced? Those are all matters of legitimate political debate where there can be varying views. Among this court, there may be varying views as to each of those questions. But that doesn't mean that a view that you may hold on that is one which can then mean that this is not itself a proper aim of the legislation and not a legitimate aim of the legislation. As Lord Reid said in SG at paragraph 73, and I took you to that at the beginning, the overall amount that is paid in benefits is a matter of political judgment. What the benefit cap does is it provides a limit. It's a well-known limit, and it sends, in a sense, a clear message to the public, to the taxpayer, as to what is the maximum amount of benefit that those who are not exempt from the cap can receive. In a sense, it is a bright line that is put in place by Parliament, but it's a bright line where there may be hard cases falling on one side of that line. Where there are hard cases, there is a mechanism to address them. There is a suggestion by the EHRC, in their case, between paragraphs 72 to 76, that a core principle emerging from the international law material regarding the right to social security is that entitlements must be assessed by reference to the needs and circumstances of the individual, and particularly so in the case of entitlements to meet the needs of children. What they rely on is Articles 26 and Articles 27 of the UNCRC, and we find that in Authorities Bundle 1, tab 7. That's the UNCRC, it's MS page 56, and we see these articles at MS 62 and 63. Bottom of the page. But you can see how caveated the language is. There is a recognise for every child the right to benefit from social security and take the necessary measures to achieve the full realisation of this right in accordance with their national law. Then it says, the benefit should, where appropriate, be granted, taking into account the resources and the circumstances of the child and persons having responsibility for the maintenance of the child, as well as any other consideration relevant to an application for benefits made by or on behalf of the child. So you can see there that it's where appropriate. So there is no international standard which is being mandated, and taking into account the resources, etc., and any other consideration. Then when we look at Article 27, which is the right of every child to a standard of living adequate for their physical, mental, spiritual, moral and social development, we can see at paragraph 2, the parents or others responsible for the child have the primary responsibility to secure within their abilities and financial capacities the conditions of living necessary for the child's development. On one view, one can say that's what the benefit cap is seeking to achieve in terms of incentivising a parent to secure through their own work the conditions of living necessary. But then we get to Article 27.3, states parties, and in accordance with national conditions and within their means, shall take appropriate measures. So entirely specific to the facts of a particular country, a particular situation at a particular point in time, to assist parents and others responsible for the child to implement this right, and shall, in case of need, this is where provide material assistance and support programs, particularly with regard to nutrition, clothing and housing. So at most, we have the reference to, in case of need, that needs to provide assistance. But again, that's in, and we say that is provided by even the level of the cap. There's also reference in Mr. Ward's statement, which you will have seen, to, I think it's at paragraph 82, he talks about other passported benefits.
Do you have the MS number of Ward's statement? Sorry.
So, my Lord,
Paragraph 82.
Mr. Ward, it's 9821 is the beginning of his evidence, and the reference to these benefits are 9851.
9851. Thank you so much.
Lord. It's in the additional witness evidence bundle. Before I get to that, just want to, going back to Article 26 and 27, it doesn't say anywhere there that you can't have, a state cannot have an overall limit to benefits. But there you can see from Ward, nutrition, free school meals are provided, available for all children first 3 years of primary school, and also available for older children. Then there's grants in respect of clothing, school clothing, etc. Needs to be taken into account. And then, of course, there's housing and housing benefit. Now, in this context, and we'll come back to this again later with the UNCRC, the EHRC cite various committee comments about the meaning of the UNCRC. We make the simple proposition that committee comments and reports are not international law by themselves. The sources of international law are set out in I think it's Article 38(1) of the International Court of Justice, treaties, international custom, general principles of law recognised by civilised nations, and then judicial decisions and teachings of the most highly qualified publicists of the various nations are subsidiary means for the determination of rules of law. There's no reference to comments of international committees. They might be persuasive so far as interpreting treaties goes, but they're not binding. And in respect of the UNCRC committee, we see that the committee is established under Article 43 of the Convention. You see that at MS 66, authorities, this is in tab 7. (45)D says the committee may make suggestions and general recommendations. This is MS 67 in the Authorities Core Volume 1. Such suggestions and general recommendations shall be transmitted to any state party concerned and reported to the General Assembly. There is no suggestion that they have any legislative power or any general power to interpret the UNCRC on behalf of its members. So we say the fairness aim is a legitimate aim, and it applies as much to lone parents or to children of lone parents as it does to anyone else. They do make up, we know, a substantial part of the cohort of those who are affected by the cap. It was known by Parliament and it was known by the Secretary of State that that would be the outcome, that there would be a substantial number. We've seen it in all the impact assessments. And the reason for it includes the fact that there are the large amounts of benefit payments are dependent on children, how many children you have. That will obviously include lone parents. So fairness applies to this cohort as much as it applies to everyone else, and it is a legitimate aim. Secondly, work incentivisation. I think everyone agrees that this is a legitimate aim. That's not surprising. Imposing a limit on benefits, we say, increases the incentives to work, and providing a work exemption, the 16-hour work exemption, provides an incentive to work. There's a focus here by the appellants on whether or not there's demonstrable evidence that the cap is actually incentivising people to work. But we say, as a matter of principle, that cannot be the test for whether something is a legitimate aim. Is work incentivisation a legitimate aim? The benefit cap, we say, can still provide an incentive to work even if people do not actually respond to the incentive. It's the incentive itself which is important. And the merit of this aim shouldn't be measured by reference exclusively by those who choose to go into work, because the measure is designed to encourage, not to compel. If households choose, in spite of the encouragement, not to go into work, that is their choice. It doesn't make trying to make them go to work, encouraging them, illegitimate or manifestly without reasonable foundation. But in fact, we say there is evidence that the cap is incentivising people to work. There's evaluation evidence about people doing more work-related activity than they otherwise would have done, and that's around half of those who were subject to the study by the department in respect of the first cap, and there's no reason why that wouldn't apply at least in the same way for the next cap. But we've also got the evidence relating to the 41% difference, or the 51% difference for lone parents. That is a difference between those who are in very, very similar circumstances. It implies causation, and it's not a misleading figure in any way. It quantifies the relative likelihood of someone going into work who is subject to the cap. One can look at the 5 percentage points, or 4.7 percentage points, and say, well, that doesn't seem like a lot, and that may be the reaction of members of this court, or some members of this court. But that has to be seen in the context of the greater relative likelihood of going to work. This is a cohort which is, for a whole variety of reasons, not going into work. But there is now a 41% greater likelihood that they will go into work as a result of the cap. Therefore, it is a big increase on what was being achieved without the cap. It also shows what was the incentive previously. Because what's been argued by the appellants is, well, there's already an incentive built into the previous benefit scheme. My lady, I'll just finish this one point. There's already an incentive built into the previous scheme because, of course, you can get more money by going into work, and you can keep lots of benefits, and you've seen those tables. But that obviously wasn't incentivizing enough people, a lot of people, because we now see that by reducing the amount of benefits, increasing the gap between what you can receive in work and what with earnings as well, and what you have without work, 41% more likely to go into work to achieve that. And we say it must be lawful for Parliament and then for the government to actually consider whether this is worth pursuing, to continue with it, to build on it, given the magnitude of what's been achieved so far. My lady.
That's an interesting way of putting things, Mr. Sheldon. We'll look forward to listening to you again at 2:00.
Thank you.